Okay, here we go with the Sarah Boone. It's not her letter, thank God, because at least it's fewer pages. Sorry for me shaking this. I am actually just got back from kayaking. I literally smell like fish, but it really was fun. And there were some fish caught, a shark seen, a sea ray caught, a flounder caught, and the tide was out, so we ended up being in sand on our kayaks, falling in the mud, but it was still fun. But anyhow, I am here now, smelling like fish because I want to dive into this Sarah Boone thing that's going to happen. And I tried to make it big so you all could see it too. And I'm trying to be mindful also that you can see it as I read it, because I'm not really looking through the camera, I'm looking at the paper. But anyhow, let's get on with it. So this was filed yesterday, the 28th. And we're going to start where it says order. This cause came before the court on June 28, 2024 on defense counsel Patricia A. Cashman's, not Coleman, who's Patricia A. Cashman's Esquire motion to withdraw as counsel, filed June 11th, 2024. The motion. The court, having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, have considered the positions offered by counsel Patricia A. Cashman, Esquire, having considered the testimony offered by defendant Sarah Boone. Okay, let me pull it down so you all can see it, because I can, but you can't. Okay. And having considered the position offered by counsel for state, hereby finds charges. Ooh, does Sarah have charges? Let's see. Make sure you can see. Okay, charges. A. On March 23rd, 2020, by way of information, the defendant was charged with second-degree murder. Procedural history. B. On February 26, 2020, the Office of the Public Defender, 9th Judicial Circuit in and for Orange County, Florida, the Public Defender and Attorney Number 1 was appointed to represent defendant. This is great because I don't even think I came in on the first attorneys. I can't remember when I hopped on this, on the Boone boat, Looney Boone boat. Okay, C. On March 9th, 2020, the public defender moved to withdraw due to defendant retaining private counsel, to wit, Mauricio Padilla, Esquire, and the Padilla Law Group. I'm just going to say Padilla. It could be Padilla, and Attorney Number 2. So she hired somebody. Okay. D. On March 11th, 2020, that certain order allowing withdrawal was entered, which withdrew the public defender from further representation of the defendant. So maybe it wasn't that she necessarily had a problem with the public defender, because she just hired, maybe at that time she had money to hire a private attorney. I'm just guessing. So E, on April 18th, 2022, Padilla, I'm just going to say Padilla, even though it might be Padilla. Padilla moved to withdraw due to irresecond. I don't know why I can't always say that correctly. And I can sometimes say it irresecond. Okay. Due to those differences, it's so funny because I know how to say the word, but my brain won't say it sometime. Okay. Arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. Okay, so that one. Okay. I'm just trying to think of the time frame. So they were, but the Padilla people were there for, okay. So that was the one that she paid. So even paying somebody was too bad. Okay. Have made it impossible for undersigned to effectively, represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain duties to the client. Yeah, these people have other cases. She acts like she's the only one and doesn't care. This motion was served upon the defendant, and defendant confirmed receipt. See letter dated April 20th, 2022, and filed on April 26th, 2022. So now we're down on F. On April 29th, 2022, a hearing was held on Padilla's motion to withdraw. At the time of this hearing, Padilla had been representing defendant for 2 years. That's pretty amazing. But probably because they were being paid. Defendant was present. Okay, we're moving this up. See? Let me see. Let me make sure you can see it. Sorry, I'm just making sure I have it to where you all can see it too. Okay, so we're right here. Sorry, on F. Where's my little? At the time of this hearing, Padilla had been representing defendant for 2 years. Defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from defendant. Oh my Lord, really? Are you kidding me? A letter dated April 20th, 2022 and filed on April 26th, 2022, which seemingly objected to Padilla's withdrawal. The court advised Padilla that the options were to not proceed on Padilla's motion to withdraw or provide the court more about the irreconcilable. I cannot say the word, guys. I know you have all heard me say it before. Those differences. I might have a fishy brain. I don't know. Okay. Padilla requested an opportunity to amend the motion to address those differences that I cannot seem to pronounce at this moment. The court reserved ruling on Padilla's motion to withdraw gave Padilla until May 3rd, 2022 to prepare and file an amended motion with a hearing to be heard on the week of May 9th, 2022. The state advised of Padilla's diligence and preparation, and the court commended Padilla's work. Okay. Defendant testified to a lack of, oh my God, I'm already getting annoyed, a lack of, oh, for the love. Let me get this up so make sure you can see. Oops. Sorry, I'm trying to look at it and make sure that you can see it too. Two years this person was with her. Oh, okay. Defendant testified to a lack of trust between herself and Padilla. Well, isn't that something? So really the first one that was appointed didn't even really get a chance. But Padilla, the one that she hired and she replaced number 1 with, the trust was not there, according to Sarah Boone. So here we go. G. On May 4th, 2022, Padilla filed an amended motion to withdraw, which supplemented the original grounds. Okay, so we're starting here. Undersigned's relationship with defendant has become adversarial. And there's another word for some reason. I am so sorry. The only excuse I'll use is I've been up since 5 this morning, so for some reason words will not come to my mouth. And I know exactly how to pronounce these words. Believe it or not, I'm an English major. Now, I may not have made all A's like Sarah did in middle school, but I can't think back that far. I know what that means, though. They didn't get along. The aforementioned relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. I'm slapping my leg. Sorry. I'm just like, oh my gosh. Undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the yes, that relationship, I'll get it, may disclose information that may prejudice his client, and as such will stand mute on the specifics. Okay, so we're moving this up. Let's see. Here we go. Okay, on May 6th, 2022, Padilla filed a second amended motion to withdraw, which further supplemented the original grounds. Undersigned relationship with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid and the fair representation of Miss Boone's defense. I'm sorry. It's making me laugh. This motion is in compliance with the Florida Judicial Amendment. These numbers, rules, legal stuff, rules regulating the Florida bar are present, or whether the attorney-client relation has deteriorated to a point where counsel can no longer give effective aid in the fair presentation of a defense. See Sanborn 474. Okay. So then we're on number 1. On May 10th, 2022, a hearing was held on Padilla's second amended motion to withdraw. Defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney. The state expressed concern of a strategy to allow defense attorney after attorney to represent defendant. So already the state was worried about this. The court advised defendant of the state's concern regarding a strategy of defendant being unhappy with every attorney, and advised defendant about the dangers of self-representation. The court appointed the public defender attorney number 3. Oh my goodness. So from the get-go. Okay. Oops. Okay, where you all can see it. On June 6, 2022, the public defender moved to withdraw due to a conflict. Wait, was there already, did number 3 come already? What? Okay, so May 10th. Does the person have a name? Okay. So it was appointed on May 10th? Okay. Oh dear, we're just talking about a month later. On June 6th, 2022, the public defender moved to withdraw due to a conflict. On June 7th, 2022, the certain order allowing public defender withdrawal was entered, which withdrew the public defender from further representation of the defendant and appointed the Office of Criminal Conflict and Civil Regional Counsel, RCC, and Attorney number 4. Okay. Okay. On June 10th, 2022, RCC moved to withdraw due to a conflict. On June 22nd, 2022, that certain order allowing the Office of Criminal Conflict and Civil Regional Counsel withdraw was entered, which withdrew RCC from further representation of the defendant and appointed Mark Counsel, and attorney number 5. On July 8th, 2022, Counsel moved to withdraw due to a conflict. Oh, my goodness. All right. On July 11th, 2022, that certain withdrawal order was entered, which withdrew Counsel from the further representation of the defendant and appointed Frank J. Bankowitz and attorney 6. And I think that is where I came in on attorney number 6, Mr. Bankowitz. So I know there were some conflicts of interest. Was there not? I feel like you all might have said it too, that at one point one of those attorneys had represented George and said that was a conflict of interest, I believe. Okay, so now we have Bankowitz. Number 6. On July 12th, Bankowitz in open court requested a continuance due to his recent appointment, and some was granted. Thereafter, the court set a pre-trial conference for October 25th, 2022 at 9 o'clock a.m. and trial during the trial period beginning November 7th, 2022. On October 25th, 2022, the court held the pretrial conference and addressed the court's understanding that a continuance was being sought, and the court's judicial assistant was to reach out to the parties to confirm if a continuance was being sought. On October 27th, 2022, Bankowitz filed defendant's motion to continue. On October 28th, 2022, the court entered that certain amended order on a defendant's stipulated motion to continue, which set a pretrial conference for January 17th, 2023 at 9 o'clock a.m. and trial during the trial period beginning January 30th, 2023. Oh my goodness. I know it's starting to get juicier and juicier. Okay. So on November 22nd, wait, can y'all see that? Let me bring that down, I'm sorry. As if y'all can hear me and I can hear you. Okay. So we are on here. On November 22nd, 2022, the court set a status hearing on Tuesday, December 20th, 2022 at 10:45 a.m. On December 19th, 2022, not Berkowitz, Bankowitz, moved to withdraw due to the I can't say the word. I'm making me crazy. You know what it's saying though. They cannot reconcile their differences. See, I can't say. Okay, I'm just. They cannot reconcile their differences, which have arisen between the undersigned, his client, and his family. The undersigned will be unable to effectively and properly continue representing the defendant herein. Okay, so due to they could not reconcile their differences, which is I'm just reading it over for myself, which have arisen between the undersigned, his client, and his family. The undersigned will be unable to effectively and properly continue representing the defendant herein. Okay. On December 20th, 2022, the status hearing was held. Bankowitz did not appear due to a car accident, and the court reset the status hearing for December 22nd, 2022 at 11 o'clock a.m. Okay, see, I don't think I was there. I came in, I guess, maybe on the tail end of Bankowitz, because I don't remember a car accident. Okay. So we're on December 22nd, 2022. The reset status hearing was held. Bankowitz appeared virtually, and due to technological issues, Bankowitz was unable to hear the court. The court reset the status hearing for December 27th, 2022. On December 7th, 2022, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. The court advised defendant that the court had received letters from defendant, a letter dated October 3rd, 2022, and filed on October 7th, 2022, a letter dated November 3rd, 2022, and filed on November 7th, 2022, and a letter dated December 5th, 2022, and filed on December 14th, 2022. The court conducted a Nelson hearing, and defendant was not seeking to remove Bankowitz. Bankowitz advised the court of the 1,000s of pages in discovery that he had reviewed and organized, and his contact and potential use of and collaboration with expert witnesses, including experts that Padilla, attorney number 2, utilized. Bankowitz advised the court of defendant's attempts to call Bankowitz at a rate of 5 to 10 times a day. Bankowitz further advised of his efforts to let me see if y'all can see the efforts to I'm trying to see if y'all can see this efforts to. I can't see this camera. I'm so sorry. I can't see this camera. Let me move it down just a little bit just in case. Efforts to. Okay. I think. Can you all see this? I'm so sorry. Okay, Bankowitz advised the court of the defendant's attempts to call Bankowitz at a rate of 5 to 10 times a day. Bankowitz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communication. In response, defendant reposted the Bankowitz's representations were untruths, raised Bankowitz's prior public reprimands for lack of communication, alleged Bankowitz's action in this case, rose to a similar level and then sought to remove Bankowitz. Oh my gosh. The court pointed out defendants' inconsistent statements within minutes of them being made and addressed concerns with defendants' motivations. Especially when there is something defendant disagreed with. The court specifically advised defendant that she is not entitled to an endless line of court-appointed lawyers until you find the one you like, is what I'm guessing it's going to say. The one that you personally prefer. The court also explained the circumstances where defendant could represent herself. Ultimately, defendant did not request to remove Bankowitz. The court denied Bankowitz's motion to withdraw and directed Bankowitz to have a conference with defendant prior to the pretrial conference previously set for January 17th, 2023. Okay, before we go on, I've just got to tell you that I don't know what it is with me and technology, and we're just even trying to get things out when I think I've got a head start on something. No, there was something on my phone, which I used to record, and then it was trying to say it needed my password. I can remember my password, so I spent like 40 minutes trying to reset it, and then I was like, what the heck is going on? And I see this jumpy stuff is going on here again. And then I noticed my knuckles were somehow appearing in there. Hopefully not the whole time. But you know what? We're still going to get this letter read. And I still smell like fish because of being on the on the East Coast today. And guess what? While I was going off through that, I just said it, irreconcilable differences. Oh my gosh, guys. I am truly losing my mind. Forgive me. And hopefully you'll have followed me thus far. And I'm not going to try to get I said, oh my God, look, that looks so creepy. Okay. So, motion to withdraw and directed Bankowitz to have a conference with defendant prior to the pretrial conference. And I'm going to put I'm going to use a pen with my hand. Okay. And that's where I left off. Previously set for January 17th, 2023. I feel like, but if I'm not mistaken, I'm back to Sarah now. I think Sarah called Mr. Bankowitz a buffoon. Now, I could be wrong, but I'm pretty sure in one of those letters by the time that they had their irreconcilable differences, she called Mr. Bankowitz a buffoon. So we're on Y there. The case was continued several times due to Bankowitz's attempts to retain an expert through JAC and JAC's response to same. And I do remember that Mr. Bankowitz was trying to retain an expert in for domestic DV. For her defense, because what else does she have, And that's not going to work well for her, I don't think. So Z says, during this time period, the court had received several letters from defendant, of course. A letter dated January 10th, 2023, and filed on January 17th, 2023. And if I'm repeating this, I am so sorry. But I'm going to keep on in case I didn't repeat it. So I hope y'all are hanging in there with me, and thank you. A letter dated March 22nd, 2023, and filed on April 14th, 2023. A letter dated April 6th, 2023, and filed on April 14th, 2023. A letter dated May 15th, 2023, and filed on May 18th, 2023. A letter dated June 29th, 2023, and filed on July 21st, 2023, and a letter dated August 2nd, 2023, and filed on August 7th, 2023. For the love of everything that's holy. Okay. So we're on AA there. Oops, there we go. So on August 22nd, 2023, Bankowitz again moved to withdraw due to, let's see if I can do it, irreconcilable differences arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. I'm telling you, Sarah thinks she's the only damn one. Okay, so there we go. The defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Miss Boone's case. I totally believe that. The best possible avenue is to have the defendant represent herself as no attorney can satisfy her. And remember in her 58-page thing, she was talking about how she was threatened by the judges about this. I don't think it's well, now it looks like it's a promise. It looks like it's a fact now. But, you know, everything is anti-Sarah. Okay, BB. On September 8th, 2023, a hearing was held on Bankowitz's motion to withdraw. Defendant, was present for the hearing and was sworn. Oh my goodness, excuse me, my Sprite. Bankowitz addressed defendant's derogatory statements. Oh yeah, dud, buffoon. See, and berating behavior. I can't blame him. The court advised defendant that the court had received letters from defendant, a letter dated August 26, 2023, and filed on September 7th, 2023, and a letter dated August 30th, 2023, and filed on September 7th, 2023. After the court's colloquy of defendant and her acquiescence, I may not have said that right either, to Bankowitz's withdrawal, the court granted Bankowitz's motion to withdraw and appointed Winston Hobson and attorney number 7. Thereafter, the court set a status conference for October 30th, 2023 at 10 o'clock a.m. and set a pre-trial conference for November 28th, 2023 at 9 o'clock a.m. After setting these dates, the court pointed out that the deterioration of the working relationship between defendant and Bankowitz. The court further continued that if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. See? So it's not like she was threatened. They're just doing their job. She doesn't want to play by the law. Only Sarah's law. So we're up here. The court further advised that there are certain decisions the attorney gets to make and certain decisions a defendant gets to make, i.e. go to trial and or testify. That's pretty much it. The court cautioned as to defendants' unrealistic expectations regarding court-appointed counsel and reminded defendant of her rights to retain private counsel. Yeah. On October 30th, 2023, the status conference was held. Hobson advised as to his conversations with defendant and setting a status in January 2024. So now we're finally in this year. Thereafter, the court set a pretrial conference status as to readiness for trial January 16th, 2024 at 9 o'clock a.m. and trial during the trial period beginning January 29th, 2024. DD. On January 12th, 2024, Hobson filed that certain motion to continue, waiver of presence, and requested a 3-docket continuance. EE. On January 16th, 2024, the court addressed Hobson's motion to continue, granted same, set a pretrial conference for May 3rd, 2024 at 9 o'clock a.m. and trial during the trial period beginning May 13th, 2024. FF. On February 1st, 2024, Hobson moved to withdraw due to irreconcilable differences, including but not limited to ethical considerations. GG. On February 9th, 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis for withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, and defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. Surprise, surprise. As to a key substantive defense, Hobson advised that the retained and undisclosed expert is not keeping with what defendant has in mind. The court advised defendant that the court had received a letter from defendant, a letter dated January 19th, 2024. The court outlined the overriding claims for withdrawal for Padilla, Bankowitz, and Hobson. There's that other word. I don't know why I'm not being able to say it. Like adversary relationships. Okay, let me find it. Okay, here we go. I'm so sorry. Okay, there we go. Relationships, lack of satisfaction, and inability to meet defendant's desires. The court found that my knuckles aren't getting in the way. The court found that all of the defendant's relationships with all court-appointed counsel have deteriorated such that defendant and the court-appointed counsel cannot work together. The court advised defendant that although defendant has a right to court-appointed counsel, that right is not unlimited. I feel like we're talking to Daryl. The court twice advised defendant that defendant may not be provided another court-appointed attorney and that the defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occur. So see, she was warned. So she acts like, and she calls it threaten. She thinks she knows everything, of course, because of all A's she made in middle school. Okay. The court further advised defendant about the dangers of self-representation due defendant's lack of legal training and knowledge. And I can think of a few other words, but never mind. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman and attorney number 8. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. The court set a status hearing for April 12, 2024. Let me just move this up. So we're right there. On April 12, 2024, the status hearing was held. Cashman advised as to the depositions that had been set, the hiring of an expert, and a request for a future status date to address a trial date. The court set a status hearing for June 7, 2024. On June 7, 2024, the status hearing was held. Cashman addressed her dates of availability for trial. Defendant was present and included, like she always wants to be, for the hearing and was sworn. Thereafter, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed. Cashman utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism and providing the court with letters dated June 4th, 2024 and June 7th, 2024, and both of which were filed on June 21st, 2024. Cashman advised to her efforts and time spent on the case so far, 20 hours. And I'm sorry if I've not moved it up to where you can see the letters, but hopefully you'll be able to follow along. Okay, 20 hours. Hang on one second. Okay, so 20 hours. Cashman addressed disagreements on legal strategy, including defendant attaching importance to issues that may not be legally important. In riposte, I finally figured out what that word was. I don't remember seeing that before. That's crazy because, like I said, I'm an English major. But it's been a long time since I wrote all those college type, papers in that form that none of us really write anymore. But anyhow, and it means that it's kind of like a quick retort, but I wouldn't consider that. But that's how they define it here. In riposte, defendant accused Cashman of lies and half-truths. Not a good thing, Sarah. Oops. Okay. Okay. JJ. On June 11th, 2024, Cashman moved to withdraw under Florida rule regulating the Florida bar, and these different letters, substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client and see, now I'm getting hung up on it. Irreconcilable differences, including but not limited to, ethical considerations have arisen such that counsel can no longer provide representation. Oh my goodness, I just can't wait to find out. Maybe y'all have already seen this. I'm never as quick on the draw as I'd like to be. I mean, I saw it like 5:30, right when I was getting ready to leave. I'm like, well, at least I'll post it in the, where we leave the messages. See, I'm telling you, my word retrieval is really bad, but I will use the excuse because I've been up since 5. That'll work, right? Okay, so KK. On June 28th, 2024, a hearing was held on Cashman's motion to withdraw. Cashman relied on Florida rule regarding the Florida bar, all that kind of stuff, and Schwab versus State. So there's, one of those things as the basis for the withdrawal. And then II, at no time has defendant refused to accept the services of any of her 7 appointed attorneys. So now we get to law. MM. Both the United States and the Florida Constitutions guarantee an indigent criminal defendant the right to assistance of appointed counsel. See U.S. Constitution Amendment, all of that stuff there. Okay, so NN, the counsel clause of the Florida Constitution under Article 1, Section 16 recognizes the right to counsel, I believe it's going to say. Sorry. Yeah. The right to counsel and results in the defendant being required. Oh, wait a minute. No, I'm reading. Oh, I got to the forfeiture. Sorry. Okay, I'm sorry. The right to assistance of appointed counsel. Okay. Then it's NN. The counsel clause. Y'all can't see NN. I'm so sorry. Okay. NN. The counsel clause of the Florida Constitution under Article 1, Section 16 recognizes the right to counsel as well as self-representation in all criminal prosecutions. And then it's another, Berkeley versus State. Okay, now we're to forfeiture of right to counsel. Ooh, okay. OO. A defendant in a criminal case can forfeit a right to court-appointed counsel. PP. A forfeiture is an extreme measure. Well, that's one word to describe Sarah, is extreme. Okay, is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation. See, it's kind of like, Daryl, those of y'all who watch Daryl, probably most of us, he lost his right to be present in the courtroom. And just like Sarah, it's not fair. It's not fair. I have rights. They're very much alike in that way. Okay, so I'm going to go to the part where it says forfeiture is a judicial response that adapts the course of the legal proceedings to the defendant's choice to engage in misconduct, sounds like Daryl, that undermines the legitimate exercise of the right to counsel. And then it's showing the citings. I'm going to go to QQ. As set forth above, defendants... Oh, Lordy. What is that word? Wow, why can't I find my words tonight? What is that? Oh, my goodness. Okay, because Oh my gosh. I'm sorry, guys. I cannot say the word. And like I said, I am so sorry. I apologize. To the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, antagonism, hostility, and attacks on the professionalism of Padilla. I think at one point it had Padilla, maybe not. Padilla, notably over a year after the fact. See footnote 9 above, Bankowitz and Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Each of the attorneys were required to withdraw. RR. It has become apparent to the court that defendant will not permit herself to be represented by anyone. You know that the shit is going to hit the fan. I can't even imagine. I just hope that she won't write any more letters because she's just, I can't even imagine. Oh my goodness. So we were RR. Okay. No, we were to QQ. We just finished RR. No, I'm sorry. QQ? Oopsie, I'm sorry. Okay. Okay, yes, QQ. I'm so sorry. At the end of QQ, each of the attorneys were required to withdraw. So sorry. Okay. And then S on SS, it says, additionally, the withdrawal of 8 different attorneys, 7 of which were court appointed, leads to a determination that defendant had forfeited his right to counsel. See all those, Watson and Waller versus State and KTT. Under Florida law, the facts at bar amount to a binding forfeiture of the rights to counsel. And then it refers to seeing something else. Okay. All right. What is going to happen? I wonder when they're going to have. Well, we'll find out. Okay. UU. As the court finds defendant has forfeited the right to court-appointed counsel under Florida law, there is no obligation to conduct Ferretta hearing or to otherwise warn a defendant of the dangers of proceeding pro se. Ooh, no obligation. Oh, wow. Ooh, and now we're coming up to waiver by conduct. Oh my gosh. All right. VV. The court can find a waiver by conduct to the right to counsel. Waiver by conduct requires that a defendant be warned about the consequences of his conduct, including the risk of proceeding pro se. On February 9th, 2024, defendant was twice advised that another court-appointed attorney may not be provided. See, that's the thing. She wants everybody to listen to her. She has her papers and questions and in the last letter, all her legal definitions as if she'd written them from some law dictionary or whatever. And she's not listening because she doesn't really care. I believe she's just trying to delay and be in control. That's what I think. Why? On February 9th, 2024. Oh, I'm sorry. She already said that. So sorry. She was advised about the dangers of self-representation. Okay. ZZ, as of February 9th, 2024, the instant case had been continued 16 times. Then has AAA. As of June 26, 2024, this case has been pending 4 years, 3 months, 5 days from the date of the filing of the information on March 23rd, 2020. Yeah, she wants to lift her days and hours and blah, 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 and everybody's wrong, and now they get to tell her. This really gives me some satisfaction because I'm really sick of her. As we probably are. Okay, triple B. Actions speak louder than words. Yeah, she's got a lot of damn words, I'll tell you that much. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and, yep, that's right. I'm loving it. I'm loving this. And encourage defendant to persist in efforts to prevent the resolution of the case on its merits. The concept of which was first brought defendant's attention on May 10th, 2022. Defendant complains that Bankowitz and Hobson, 2 court-appointed attorneys, failed to meet and communicate. And when defendant is provided court-appointed counsel who will meet and communicate, Cashman, which she went above and beyond, I think, the ways and means of meeting and communicating are unacceptable to defendant. I'm telling you, she blew it. I think Cashman, all that experience, she just, Sarah wants to be in charge. Okay, we're down to triple C. Under Florida law, the facts at bar amount to a binding waiver of the right to counsel. And see Jackson versus State. Okay, orders and adjudges as follows. 1. Cashman's motion to withdraw as counsel filed June 11th, 2024 is granted. Oh, God bless you, Patricia Cashman. I bet you were happy to hear that. Okay, number 2. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for costs to obtain transcripts of depositions for the 2 witnesses Cashman deposed. Upon completion of the transcription of the depositions transcript shall be sent directly to defendant Sarah Boone by Cashman at the Orange County Jail. Thereafter, Cashman shall file a notice with the court reflecting that the I'm thinking of Sarah's disposition, that the depositions transcripts were provided to defendant Sarah Boone, and such notice shall include the date set and the address of the defendant Sarah Boone. Number 3. Defendant Sarah Boone has forfeited her right to court-appointed counsel. 4. Alternatively, defendant Sarah Boone has, through waived by her conduct, her right to court-appointed counsel. Oh my gosh. What is going to happen next? Okay. So 5 says, number 4. Nope. Never mind. Number 5. The trial management conference shall remain specifically set for Tuesday, September 24th, 2024 at 1:30 p.m. Ooh, hot damn. Okay. Here we go. 6. This case shall remain specifically set for trial for the 2-week trial period beginning Monday, October 7th, 2024, and will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by the defendant. Wow. Okay, 7. Any and all pretrial motions in this case must be filed no later than the close of business on Monday, July 22nd, 2024. Done and ordered in chambers at Orlando, Orange County, Florida, this 28th day of June, 2024. Oh my goodness. Wow. And there's the judge, Michael S. Kranick. Let's see, is there anything else? Okay. Certificate of Service. I hereby certify that the foregoing was filed with the clerk of the court this 28th day of June, 2024, by using the Florida Court's e-filing portal system. Accordingly, a copy of the foregoing is being served on this day to all attorneys, interested parties identified on the e-portal, electronic service list via transmission of notices of electronic filing generated by the e-portal system. Hereby certify that a true and correct copy of the foregoing has been furnished to each of the said parties by hand delivery on this 28th day of June, 2024. Hand delivered, just like Sarah did. Okay, so there's that. This should be interesting. Yeah, I honestly don't think Sarah really has anywhere to go. I know at one time when I think I had posted this letters that she was upset with her ex, Brian, because I think he was paying her alimony, and I'm not sure, but I don't know if like once you're incarcerated, maybe you're not entitled to the alimony anymore. I'm not sure about that, but she was really mad at him about that. But where's she going to go, honestly? She really has nowhere to go. You know, she can sit there and just, I guess, write. I don't know, but this is crazy. This is crazy. So what I would advise you all to do, you know, I know, and you may have already done this, I don't know, but I always say, like, if you want to go for the legal aspect of it, breaking it down, I always recommend Peter from Lawyer You Know. And I just started watching, and I really like Dr. Berry. She's a psychologist, and I saw that today, and maybe if y'all follow her, maybe you were on, I think she had a live today, like at 2 o'clock. So you'll be, if you haven't seen that already, she kind of breaks that down, you know, the psychological side of it. So you get the law side and the psychological side, which those are both two good people to go to if you've not watched them. I really like both of them. But there's that. So we will wait and see. I don't even know, there's no point for her to write any more damn letters, but will she still do it? Wouldn't you love to be a fly on the wall to see how she reacted? Everything's going to be so unfair. Is it unfair? Yeah, it's unfair what you did to George. And, you know, no, she, you know, I'm thinking back when she was just all anxious, you know, after the crime, and they came there, and she kept wanting to go in there and get her damn Dr. Pepper and get a cigarette. And they were telling her, no, you're going to mess up the crime scene. And it's just like everyone, just like Daryl and Sarah and Hannah Payne and Shauna and Paul Vander Ark and all these other people that some of us follow, and most of us, there is no remorse. There's nothing, no concern, no sadness, no grieving, no nothing. Nothing like I miss him. Oh, I didn't mean to do it. No remorse, no nothing. It is all about them and their needs, because as far as they're concerned, they're the most important ones. And that's probably why Brian Boone, Sarah's ex-husband, has custody of their child. Because poor guy, he's certainly been cheated out of a mom. And then poor George's family still waiting, waiting to get justice for George. It's crazy. All right, so there's that. So sorry, guys. And I'm going to attribute it mostly to me being tired, but I hope that it wasn't too aggravating for you all. And oh my goodness, I think at one point I remember there was some sort of gnat or fly that got in here, and it was flying around, and I was trying to bat this. I don't know, but if y'all don't know, if you see a bug is on my end, it's so bizarre. What a weird day. But anyhow, there's that. We got through it, and I am really interested to see how this is all going to work. Is Sarah just going to sit there and say, sit there with her arms folded and say, I'm not going to say anything. I'm not going to do anything. I guess they could just go on and proceed, couldn't they? And, oh my gosh, that is so crazy. I hate that it's starting in September because it's not that far away from me. I would totally go into the courtroom, but, I kept hoping it would happen this summer, but, oh well, it is what it is. But, okay, I've kept you long enough, I know. And I apologize for stumbling over the words. I know I missed some words here and there, but I do my best. But I think we get the gist of it. Sarah has lost her right to attorneys. And it does, they didn't say anything about a standby attorney either. I know sometimes they do that, but I guess she got nothing. She got nothing. And all of that writing she did, didn't do her damn bit of good. Well, except lose her some attorneys. But that's on her. Okay, I'm really going this time. Thank you all guys so much for watching, commenting, subscribing. I really do appreciate each and every one of you if I could get my words out. I love you all. Be kind to one another. Be kind to you. And I'll see you the next time. Bye.
The reason why I'm here is to hope that she will come in with a gentle, softer side and actually listen to what it is that I'm saying and see the bigger picture other than what's the one avenue that she keeps going down. There's other ways to win and more than one way. I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me.